Good morning to all. Now I am going to present Business Law and Ethics prepared by KY Karpaham of First BCom CA. Now let us see what is Contract of Guarantee. Section 126 of Indian Contract Act 1872, which deals with the contract of guarantee, has defined it as a contract to perform the promise or discharge the liability of a third person in case of his defaults. This contract of guarantee, it involves three parties, namely first one surety, who gives the guarantee. Second one, principal debtor, in respect of whose default the guarantee is given. Number 3, creditor, to whom the guarantee is given. For example, A supplies goods to B on C's guaranteeing payment by B to A. This means if B does not pay, C would be liable to pay. This is a contract of guarantee. Here, B is the principal debtor, C is the surety, and A is the creditor. Guarantee may be either oral or written. Just like any other contract, it should also fulfill all essentials of valid contract. As stated already, three parties are involved in the contract of guarantee. At the same time, there are three collateral contracts also, namely first one, as between A and B, A supplies goods to B on credit whose promises that he would pay. Number 2, as between A and C, C gives guarantee the price of goods it will pay. Number 3, as between C and B, B indemnifies C in case of B's default in paying the amount to A. Now, let's see the essential of a contract of guarantee. First one, concurrency of all the parties. All the three parties, namely the principal debtor, the creditor, and the surety, must agree to make such a contract. Second one, liability. In a contract of guarantee, liability of surety is secondary. That is, the creditor must first proceed against the debtor, and if the latter does not perform his promise, then only he can proceed against the surety. Third one, extension of debt. A contract of guarantee presupposes the extensions of liability which is enforceable at law. If such no liability exists, there can be no contract of guarantee. Thus, where the debit which is sought to be guaranteed is already time buried or void, the surety is not liable. Consideration. There must be consideration between the creditor and the surety so as to make the contract enforceable. The consideration must also be lawful. In a contract of guarantee, the consideration received by the principal debtor is taken to be the sufficient consideration for the surety. Number 5. Writing not necessary. A contract of guarantee may either be oral or written. It may express or implied from the conduct of parties. Notes. A contract of guarantee must always be in writing under English law. Number 6. Essential of a valid contract. It must have all the essential of valid contract such as offer and acceptance, intention to create a legal relationship, capacity to contract, genuine and free concern, lawful object, lawful consideration, certainty and possibility of performance, and legal formalities. Number 7. No concealment of fact. The creditor should disclose to the surety the facts that are likely to affect the surety's liability. The guarantee obtained by the concealment of such fact is invalid. Thus, the guarantee is invalid if the creditor obtains it by the concealment of material facts. No misrepresentation. The guarantee should not be obtained by misrepresenting the fact to the surety through the contract of guarantee is not a contract of absolute good faith and thus does not require complete disclosure of all the material facts by the principal debtor or creditor to the surety before he enters into the contract but the facts that are likely to affect the consent of surety's responsibility must be truly represented. Thank you.